How to negotiate a severance. We get hired to negotiate a severance all the time on both the employer and the employee side. So here's just a handful of things that you need to take into consideration when you're trying to negotiate a severance. So, one, is it based on a contract? Is the severance something that you agreed upon in your employment agreement in the past? And if so, you're typically going to have to follow, in large part, the terms of the severance agreement that you've already agreed to. We see this a lot with the executive level. They're making probably a big move from one executive position to another at another office. So they're going to negotiate for themselves something just in case there's a termination or it doesn't work out and they just lost a great position, some kind of severance. It's probably not you. So if it's not you, you get terminated, you need to think to yourself or contact an employment attorney and ask, do I have a case? Is the circumstances of my termination such that I actually have a case? Because when you're negotiating for a severance to break up the relationship between the employee and the employer, what you're doing is saying, I want to make an agreement with you. I want to agree that I will not sue you for the things that have taken place here at the workplace. And in order to do that, I'm going to need some kind of compensation. Continuation of medical benefits is a big one. And whatever else might be on your mind. Now, for example, alternative compensation, we negotiated a severance in large part from about 70,000 to 320,000. And what that was about was restricted stock units that this employee was granted, not options to buy, but granted. He was granted stock in the company for being there for a certain period of time, over 20 years. And when they terminated him, they wanted to severance him for just 70,000, stating that this is the value of the restricted stock units that were otherwise granted, and the rest of it you wouldn't be entitled to. Now, the circumstances of the termination, completely outside of the employee's control. The company had sold to another company. New ownership came in. They resold it immediately. All that stock had disappeared, and they're paying out people. But there was a provision in this agreement that would allow him to collect the entire RSU bank. And that's how we were able to get that money for him. In other cases where there's nothing like that, when you're wanting to negotiate your severance, you need to come at it from a place like a demand letter or like an employment demand. What causes of action do I actually have against the company? Was I retaliated after speaking up against workplace concerns, or was I grossly underpaid? Was my salary misclassified? Am I not being accommodated for my disabilities? Was there sexual harassment? Something like that. You need to have teeth, because employers do not want to give you a severance agreement, obviously, because it's just money out of their pocket for what? They've already fired you. So you need to be able to explain to them why it is this is in their best interest. So the way that we negotiate severances and the way that you should too, keep in mind the mindset in something like this. It's calm. Like you don't want to come in guns blazing like, I have a case, I'm gonna sue you. You guys did all these messed up things to me. And this is just the way that we're going to handle it. You're not going to get traction like that. You say, look, typically you want to do this in writing to management, HR, whoever is a decision-making authority, and say, look, the circumstances of my termination are suspect because they came immediately after I made complaints of this kind, or they came immediately after I suffered an accident at work, outside of work. If it's at work, workers' comp, you'll deal with that. If it's outside of work, like I needed an accommodation for this disability, I just needed some time off, and instead you terminated me. I don't want to bring a claim for disability discrimination under the Fair Employment and Housing Act or the American with Disabilities Act. But obviously it's going to take me time, one, to recover, and secondly, to find another job. I'm going to need something to stay on my feet for the next 6 to 12 months while I recover from this injury, depending on how big it is. So what you're doing is you're notifying them, look, I actually have a case against you and I'm aware of it. The fact that I'm aware should put you on notice that I will do something about it if we can't get a severance going. Competent employers with defense counsel will read that. They will know exactly what you're doing. You're not sneaky. But the point is, you're not trying to be. You're not trying to sneak something by. You're trying to let them know, like, look, like I will do this. I will sue you. But you do it in a kindly worded letter. And then typically what's going to happen is they'll come back and say, you know what, we agree, we'll give you $3,000 to go, to go away. Um, what is the value of a severance? It really depends. The best way to calculate severance is what's the reasonable amount of time it'll take for you to find a comparable position. And the higher up you go, the more difficult it becomes. The more niche the market, the more difficult it becomes. The smaller the industry, the more difficult that becomes, especially if your job opportunities are with rival companies and they're going to want to know why you were let go. So salary times number of months is largely incorrect, or largely correct for the number of months that you're going to be out of work. I always try to default between 3 and 12 in increments of 3, 6, 9, 12 months. If you don't necessarily have a strong case, should you still request a severance? Yes. Employment lawsuits in California, they're skyrocketing. Everybody's suing. There's billboards on the freeway. Sue your boss, F you bully. Shout out MVP trial attorneys. I really like their billboards. Good friends of mine. And so employers have been getting sued left and right over nonsense cases. So they understand the cost of litigation. And that alone will sometimes get you a severance. But if you were drastically underperforming and a nuisance in the workplace, probably not the best way to do it. So what I want you to do is you need to come up with, first check your employment agreement. Make sure that this wasn't already pre-negotiated if there was a separation of employment. 2, why were you terminated? Is this a form of retaliation, discrimination, failure to accommodate, something like that? If it is, kindly put them on notice. If you want to get an attorney for this, that's the best way to do it. That way they really know something's about to go down. And remember, these are kindly worded documents, kindly worded emails. It puts them on notice, but it doesn't invite challenge. So what a lot of employers do, especially smaller employers, is this is personal. And when you tell them, I'm going to hurt your business, they feel like they have to take a stand. But when you say, hey, the only person here that got hurt is me, and all I'm asking is for you to help me stay on my feet while I get my next job and move on peacefully. That messaging, that type of context comes a lot easier. And if you are going to get an attorney, you need to look up who the attorney is. Are they competent counsel? Are they somebody who's known to litigate? Is there a real threat behind that law firm? Do they go to trial? Do they take cases to the very end and put it in front of a jury? That alone is going to get you the kind of results you need. So some tips just for negotiating your severance. Take all this into consideration. The higher up you've been, the longer you've been there, do you have a case? How long is it going to take to get reemployed? And the big one is, do not get greedy. Do not get greedy. If you're trying to negotiate this yourself, you need to be honest. And if what I see when people bring me in after the fact, when they were trying to negotiate their severance by themselves, is they were asking for like $500,000 to $1 million, $500,000 to $1 million for a severance. They made a demand to the employer. Maybe they did all the other steps, but the demand number was $500,000 to $1 million, and the employer's like, "Fuck you! There's no way. We're not going to do that." And the reality was, you made like, $5-6 grand a month. You're not going to get anywhere with that unless you were, grossly sexually harassed or something like that. For the average termination, that's not realistic. Start with wages. It's going to take me 3 to 6 to 9 to 12 months to find an alternative position that's comparable, and at most multiplier of 3 without an attorney. So 3 months, 3, multiply that by 3 for any kind of additional emotional distress damages. They'll counter and come back with something else. They might also give you an FU letter, say they're not going to discuss anything. That's when you would get an attorney involved. But the growing landscape in employment in California is that they want to give you a severance. They want to settle with you before the case even begins, because defense attorneys nowadays are charging anywhere from $300 would be like a super discount, but as high as $1,000 to $1,200 an hour. I would say average about $550, $600 an hour to handle these types of claims. So it can get expensive for the employer too. Do not throw that in their face. Don't challenge them to do it. Like I said, you're humble. They're negotiating from a position of humility with teeth. And if they refuse to negotiate, that's when you get an attorney in, and let the attorney be the one who negotiates it with actual teeth and threats, and says, look, this is your fate should you not resolve this situation. So take with that what you will.